The Jewish tradition describes certain forms of corporal punishment and capital punishment for certain crimes, while cautioning against the use of such punishments. Capital punishment in classical sources. The harshness of the death penalty indicated the seriousness of the crime. Jewish philosophers argue that the whole point of corporal punishment was to serve as a reminder to the community of the severe nature of certain acts. This is why, in Jewish law, the death penalty is more of a principle than a practice. The numerous references to a death penalty in the Torah underscore the severity of the sin rather than the expectation of death. This is bolstered by the standards of proof required for application of the death penalty, which has always been extremely stringent. Because the standards of proof were so high, it was well nigh impossible to inflict the death penalty. The Mishnah outlines the views of several prominent 1st century CE rabbis on the subject. A Sanhedrin that puts a man to death once in 7 years is called destructive. Rabbi Eliezer ben Azariah says that this extends to a Sanhedrin that puts a man to death even once in 70 years. Rabbi Akiba and Rabbi Tarfon say, had we been in the Sanhedrin, none would ever have been put to death. Rabban Simeon ben Gamaliel says, they would have multiplied shedders of blood in Israel. The Sanhedrin stopped issuing capital punishment either after the Second Temple was destroyed in 70 CE or alternatively, according to passages in the Talmud and New Testament, in 30 CE when the Sanhedrin were moved out of the Hall of Hewn Stones. Other sources such as Josephus and other passages in the New Testament disagree. The issue is highly debated because of the relevancy to the New Testament trial of Jesus. Ancient rabbis did not like the idea of capital punishment, and interpreted the texts in a way that made the death penalty virtually non-existent. The idea of killing someone for a crime they commit is frowned upon in the Jewish tradition. The 12th century Jewish legal scholar Maimonides stated that, it is better and more satisfactory to acquit 1,000 guilty persons than to put a single innocent one to death. Maimonides argued that executing a defendant on anything less than absolute certainty would lead to a slippery slope of decreasing burdens of proof, until we would be convicting merely according to the judge's caprice. Maimonides was concerned about the need for the law to guard itself in public perceptions, to preserve its majesty and retain the people's respect. Stringencies of evidence in capital cases. It requires 2 witnesses who observe the crime. The accused would have been given a chance, and if repeated the same crime or any other, it would lead to a death sentence. If witnesses had been caught lying about the crime, they would be executed. 2 witnesses were required. Acceptability was limited to adult Jewish men who were known to keep the commandments, knew the written and oral law, and had legitimate professions. The witnesses had to see each other at the time of the sin. The witnesses had to be able to speak clearly, without any speech impediment or hearing deficit. The witnesses could not be related to each other or to the accused. The witnesses had to see each other, and both of them had to give a warning to the person that the sin they were about to commit was a capital offense. This warning had to be delivered within seconds of the performance of the sin. In the same amount of time, the person about to sin had to respond that he was familiar with the punishment, but they were going to sin anyway, and begin to commit the crime. The Beth Din had to examine each witness separately, and if even one point of their evidence was contradictory, even if a very minor point, such as eye color, the evidence was considered contradictory and the evidence was not heeded. The Beth Din had to consist of minimally 23 judges. The majority could not be a simple majority. The split verdicts that would allow conviction had to be at least 13 to 11 in favor of conviction. If the Beth Din arrived at a unanimous verdict of guilty, the person was let go, the idea being that if no judge could find anything exculpatory about the accused, there was something wrong with the court. The witnesses were appointed by the court to be the executioners. As a result, convictions for capital offense were rare in Judaism. The 4 types of capital punishment. Before any capital sentence was carried out, the condemned person was given a drug to render them senseless. There were 4 types of capital punishment, known as mitath beth din. These 4 types of capital punishment, in decreasing severity, were secular stoning. This was performed by pushing a person off a height of at least 2 stories. If the person didn't die, then the executioners brought a rock that was so large that it took both of them to lift it. This was placed on the condemned person to crush him. Serapha Burning. This was done by melting lead and pouring it down the throat of the condemned person. Hereg, decapitation. This is also known as being put to the sword. Chenek, strangulation. A rope was wound around the condemned person's neck, and the executioners pulled from either side to strangle the condemned person. Capital sins separated by the 4 types of capital punishment. The following is a list by Maimonides in his Mishneh Torah of which crimes carry a capital punishment. Punishment by secular intercourse between a man and his mother, intercourse between a man and his father's wife, intercourse between a man and his daughter-in-law, intercourse with another man's wife from the first stage of marriage, intercourse between 2 men, bestiality, cursing the name of God in God's name, idol worship, giving one's progeny to Molech, necromantic sorcery, Pythonic sorcery, attempting to convince another to worship idols, instigating a community to worship idols, witchcraft, violating the Sabbath, cursing one's own parent, a stubborn and rebellious son. Punishment by Serapha. The daughter of a priest who completed the 2nd stage of marriage commits adultery. Intercourse between a man and his daughter, intercourse between a man and his daughter's daughter, intercourse between a man and his son's daughter, intercourse between a man and his wife's daughter, intercourse between a man and his wife's daughter's daughter, intercourse between a man and his wife's son's daughter, intercourse between a man and his mother-in-law, intercourse between a man and his mother-in-law's mother, intercourse between a man and his father-in-law's mother. Punishment by hereg. Unlawful premeditated murder, being a member of a city that has gone astray. Punishment by chenek. Committing adultery with another man's wife, where it doesn't fall under the above criteria. Wounding one's own parent, kidnapping another member of Israel, prophesying falsely, prophesying in the name of other deities. A sage who is guilty of insubordination in front of the grand court in the chamber of the hewn stone. Corporal punishment. In classical sources, there was only one form of corporal punishment, lashes. The maximum number of lashes allowed per sentence was 40, given in multiples of 3, effectively making the maximum 39. Apart from as a punishment for violating Torah law, Malkuth Mardis was also administered in cases of contempt of court in violation of rabbinic law, where the court lashes the violator to the extent they see fit. Contemporary attitudes towards capital punishment. Leading rabbis in Reform Judaism, Conservative Judaism, and Orthodox Judaism tend to hold that the death penalty is a correct and just punishment in theory, but they hold that it should not generally be used in practice. In practice, the application of such a punishment can only be carried out by humans whose system of justice is nearly perfect. A situation which has not existed for some time or never existed at all. Rabbinical courts have given up the ability to inflict any kind of physical punishment, and such punishments are left to the civil court system to administer. But the modern institution of the death penalty is opposed by the major rabbinical organizations of Reform, Conservative, and Orthodox Judaism. Reform Judaism since 1959. The Central Conference of American Rabbis and the Union for Reform Judaism have formally opposed the death penalty. The CCAR resolved in 1979 that both in concept and in practice, Jewish tradition found capital punishment repugnant, and there is no persuasive evidence that capital punishment serves as a deterrent to crime. Conservative Judaism. In conservative Judaism, the death penalty was the subject of a responsum by its Committee on Jewish Law and Standards, which has gone on record as opposing the modern institution of the death penalty. The Talmud ruled out the admissibility of circumstantial evidence in cases which involved a capital crime. 2 witnesses were required to testify that they saw the action with their own eyes. A man could not be found guilty of a capital crime through his own confession or through the testimony of immediate members of his family. The rabbis demanded a condition of called premeditation in the act of crime before they would sanction the death penalty. The specific test on which they insisted was that the criminal be warned prior to the crime, and that the criminal indicate by responding to the warning that he is fully aware of his deed, but that he is determined to go through with it. In effect, this did away with the application of the death penalty. The rabbis were aware of this, and they declared openly that they found capital punishment repugnant to them. There is another reason which argues for the abolition of capital punishment. It is the fact of human fallibility. Too often we learn of people who were convicted of crimes and only later are new facts uncovered by which their innocence is established. The doors of the jail can be opened. In such cases we can partially undo the injustice, but the dead cannot be brought back to life again. We regard all forms of capital punishment as barbaric and obsolete. Rabbi Ben Zion Boxer, Statement on Capital Punishment, 1960. Proceedings of the Committee on Jewish Law and Standards, 1927–1970, Volume 3, pp. 1537–1538. Orthodox Judaism. Orthodox Rabbi Yosef Edelstein writes, so, at least theoretically, the Torah can be said to be pro-capital punishment. It is not morally wrong, in absolute terms, to put a murderer to death. However, things look rather different when we turn attention to the practical realization of this seemingly harsh legislation. You may be aware that it was exceedingly difficult, in practice, to carry out the death penalty in Jewish society. I think it's clear that with regard to Jewish jurisprudence, the capital punishment outlined by the written and oral Torah, and as carried out by the greatest sages from among our people, did not remotely resemble the death penalty in modern America. In theory, capital punishment is kosher, it's morally right, in the Torah's eyes. But we have seen that there was great concern, expressed both in the legislation of the Torah, and in the sentiments of some of our great sages, regarding its practical implementation. It was carried out in ancient Israel, but only with great difficulty, once in 70 years, not 135 in 5.5. Rabbi Yosef Edelstein, director of the Savannah Kollel Orthodox Rabbi Aryeh Kaplan writes, in practice, however, these punishments were almost never invoked, and existed mainly as a deterrent and to indicate the seriousness of the sins for which they were prescribed. The rules of evidence and other safeguards that the Torah provides to protect the accused made it all but impossible to actually invoke these penalties. The system of judicial punishments could become brutal and barbaric unless administered in an atmosphere of the highest morality and piety. When these standards declined among the Jewish people, the Sanhedrin voluntarily abolished this system of penalties. Rabbi Aryeh Kaplan, Handbook of Jewish Thought, Volume 2, pp. 170–71. On the other hand, Rabbi Moshe Feinstein, in a letter to then New York Governor Hugh Carey states,